Every Tuesday evening at 5 p.m. Central Time, we do bring Immigration Update live from Houston, Texas. Emily, what do we have today to discuss?
Yeah, today we want to talk about what's going on in the Middle East and how it is impacting ability to travel, which means how is it going to impact people that are on US work visas. We'll also talk about the H-1B cap. The lottery registration process opens tomorrow at noon Eastern time. What people should expect from that, what to prepare for this year, what is the process going to look like, what'll be different. And then we'll talk about the visa bulletin. Why is it so hard to predict the visa bulletin? Why does it just feel like a puzzle that no one can solve? And lastly, we have a lot of people who are in the situation of having their adjustment of status. Their 485 is already filed, it's been pending. Priority date becomes current under the final action date, but the case is still pending. Why isn't the case getting approved, and what you can do to try to push that along?
On the thing of US-Iran war, as we know that there are some people that are stuck in the Middle East where they could not travel to their home destinations or back to United States because of the war. Definitely, we want everybody's safety at this point of time. If anybody is planning to travel to their home country, if it falls that you're going through the Middle East, definitely the routes are closed right now. We strongly recommend anybody who is on an immigrant visa right now not to travel at all. That's been our recommendation from the beginning itself. Nothing new with this one. But of course, there's more restrictions right now. There are situations where people are here on a B2 visa. What if their I-94 is expiring? You could file an online B2 extension. If you are on a H1B, L1B, you lost a job and you have to leave the country within a certain speculated time. And if you can't leave because you can't get the tickets right now, of course you can't. And you could file a B2 and you could file an online application to stay legal. There are situations where, particularly for the B2 visas, their passport visa becomes invalid if you stay one single day over the limitation of the I-94 that is given. But if you file a B2 application, which you can file it online I-539 application, you can file for 2 to 3 months just so that things will get cooled down and then you can travel when the things permit. And the USCIS should be very considerate. Hey, I have a travel plans, I have my ticket booked. Right now, the things are canceled. Here's the situation. So they should be fine in extending it. As long as you file the application, even if you don't get the approval by the I-94 expiration, you will be in a safe state. And this overall war might have some negative consequences on the immigration itself. Now, those people who got the visas, visa doesn't just, if the flight doesn't get out of the ground, you cannot come into the United States. And there are situations where people have left the country and they may lose their jobs if they don't come back, if they don't allow remote working. So you may request the employer, hey, look, the situation is very bad. They may be considerate. Most of the people they become very considerate, especially in the war situation, though. So they may allow you to work remotely, or they may extend the time for you to travel into United States. So you may request based on the war situation how the things are. Emily, any other travel warnings for the situation here?
Yeah, I mean, again, we recommend not traveling outside the US if you are here. As you said, if you have lost your status or are going to lose your status and we're planning to leave but can't, the most important thing is don't do nothing. Don't stick your head in the sand and assume it's all going to work out. Act before the deadline, file something, file the I-539 online. Um, and just, understand that nowadays our visa policy is very much following our foreign policy, to where if we don't like a particular country, we as a country are not going to make it easy for citizens of that country to get visas to come into the US. I know a big issue right now is third country national processing of visas is no longer available. So people have to apply in their home country. But what if their home country consulates are closed because they're under security issues? They're being threatened right now, being bombed, and those sorts of things. I don't think our government is going to make it a priority to provide some other way for people in those countries to get a visa elsewhere and come into the US. I think that um, for people that are in that situation, it's not likely that they'll be able to get a visa. Unfortunately, our country is kind of changing its how it stands in the world, and this is just the outcome of that.
Emily, what about the H-1B cap? Now, on March 4th, the lottery begins, and it's based on the wage base. That means that if you are at level one, you will get only one chance. You will get, if you're level two, you'll get two chances. Level three, three, and level four, four chances. What are the deadlines? What is expected from March? Everybody knows that from March 4th to March 19th is the time for them to apply. The employer has to enroll, and what is the process involved?
Yeah, so if the company doesn't already have a My USCIS account, they need to set that up now as an H-1B registrant. If they're using an attorney, they need to connect their account with the attorney's account. So when the attorney submits the registration, the company can go into their account, review the registration and accept it. Then it goes back to the attorney to pay the fee and actually submit the registration. We do have until March 19th to get those done. After that point, we expect, as usual, to start hearing back on results around March 31st. Typically, we've started seeing things a few days early, like the Thursday before. So maybe the 26th or 27th, we might start seeing those lottery selection notices rolling in. The notice only gets uploaded into the attorney account or the employer account. So the employee is not notified in any way. So the employer or their attorney will need to reach out to the employee and let them know if they were selected or not. And then the filing window opens April 1st. You can file through June 30th. This year, it needs to be filed as a change of status. Otherwise, if it's consular processing, the $100,000 fee is going to apply, which no companies are really paying that right now. Other things to be aware of, I would say, because the lottery is different this year, because it's wage-based, expect the unexpected, which is a little hard to plan for, but we've already seen that the I-129 form has been updated. The new version of the form has to be used starting April 1st. It has a new section on it that asks for the wage level that was used in the lottery registration. It also has a new section that asks for information about the job offer. What is the minimum education required? What is the minimum education field of study required? What is the minimum years of experience required? Are there any special skills required? Are there any licenses or are there any supervisory duties involved? Why are they asking all of that on the I-129 form? They want to make sure that your LCA actually corresponds to the position that you've been offered, because the LCA is where the company selects the wage level that applies, the prevailing wage. There are 4 different wage levels. And so depending on the combination of education level, experience, special skills, and supervisory duties, that will determine which wage level is the correct one. So we can expect that USCIS is going to be taking that information and looking at the LCA to verify that the wage level is correct. Now, all that to say, this is technically DOL's job. USCIS is not supposed to have anything to do with this. It would make a lot more sense if the LCA form was updated to ask for this information and the DOL was actually reviewing this information when they were adjudicating the LCA. That's not what's happening. So I can expect there's going to be new types of RFEs that we've never seen before as a result of this information being added to the form. They're likely going to be asking for additional documentation that the wage level was actually correct based on the information that's provided in the form. And maybe they'll ask for information corroborating what was mentioned in the form, because they're not going to just believe you when you say it in the form. They're going to want proof of that. What would that proof look like? I have no idea what they're going to want. I would expect job vacancy announcements that the company has posted to try to recruit for the position is very likely. So you want to make sure that you have all of your ducks in a row on that, on what does the job actually required, so that you can be prepared in any kind of new request for evidence. This issue has been coming up in site visits for the last several months. And I think by adding it to the form, they're just making it easier for USCIS to potentially deny if what is listed on the form does not correspond to the prevailing wage used on the LCA.
Okay, Emily, visa bulletin. Now the dates move backward, the move forward, and it used to be January 1st, 2015. In 2020 October, and right now we are in 2026. We haven't even touched that date in EB3. And why is that dates move forward, move backward, forward, backward, sometimes sideward? Why can't you predict it? You have got the law degree, you paid so much money for the law degree, you went to this one, you speak in all those conferences, you claim to be an immigration lawyer for past 20 some years, and why can't you tell at least with some reasonable certainty about the visa bulletin?
Yeah. Number one, we don't even know how many green cards are available this year in employment base. They still have not announced whether it's 140,000 or something more, because we know that unused family-based green cards from the prior year spill over to employment based. We don't have that number yet. I think number two is there is no way for USCIS to track upgrades and downgrades between EB2 and EB3, because a perm that qualifies for EB2 also qualifies for EB3. And they made a major miscalculation in October 2020 when they moved those dates the way they did. They didn't realize how many people were going to downgrade. And then that creates, since then, this whole pipeline of people that are just waiting. A lot of them have multiple I-140s, a lot of them have multiple 485s. We don't know how many of those there are. We don't know who's going from EB2 to EB1, or maybe they're going to EB5. There's just a lot of uncertainty. And then on top of all of that, we don't know, the way it's set up is unused EB1 numbers spill down to EB2, and then unused EB2 rest of world numbers spill across to the last oldest priority date, which is generally going to be India. But how many are going to go unused? They don't know. They just, move the date based on what they see as the demand right now. But if that demand increases unexpectedly and they see a bunch of EB2 rest of world cases coming in, that's going to leave less for India in EB2. And so that date's going to move more slowly than what we have anticipated. So there's just so many inner workings, and nobody knows how many people are actually in line to figure out how long the line really is.
And yeah, guys, keep following. It's going to be very hard to predict. We have seen some good improvement in EB2. There may be some fallouts where the employment-based immigration applications, we may get some more family-based because of the country bans. And also, we have seen some consulate closures right now, especially in the Middle East and some other areas, that also might get some extra green cards for the employment-based green card. So we may get some extra numbers. Could the movement be like what happened in 2020, where it moved for 3 to 4 years at a single stretch, or 5 years at a single stretch? Or could it be that it may just move a little bit, or could it be it may not move? We are expecting some movement, but as I pointed out that Emily is one of the worst predictor of the priority date, and she is the second worst predictor of the priority date. I claim the first prize, and she claims the second prize. Yeah, don't trust on that, but there are some expectations based on broad based at this point of time. It's very hard to predict the priority date, guys. But let's see how it goes on. If people who have been working in United States and they have a priority date that is very close to January 15th of 2000, January of 2015, may not want to leave their jobs at this point of time. If the company has that they're working did not apply for the labor certification, they probably would want to have the labor certification process so that they'd be ready for filing the 485 application. Emily, for those people who filed the 485 application in 2020, and of course, so for some of them, the priority dates are current right now. They were current in between, they went back and they came forward. Now they are current. Why isn't their cases getting approved?
I think that USCIS is very inefficient in how they're tracking this. The files are spread out between the National Benefit Center and all of the field offices all over the country. Some of them are at local service centers too. And I don't think they have a way to track when a priority date becomes current, automatically pull the file and then adjudicate. And there's just no motivation for them to do that either. I mean, back in the day, I don't know if you remember, but we used to be able to send an email that had the person's A number in the subject line and nothing else to a special email box that they had set up for attorneys, where the date became current, and they would actually monitor those emails, pull the files, and start adjudicating them. That's been long gone, which seems kind of crazy because there should be a better way to track it now. And I don't know if they have any with all of their technology and the scanning that they do in the lockbox. This is the worst it's ever been, I feel like. I don't know. What are your thoughts on that?
Definitely, this is the worst thing. What they're doing is not adjudicating the applications. What I strongly recommend is that if your 485 has been pending for more than 1 year and your priority date, final action date is current right now, it doesn't have to be current from past 1 year. We recommend to file a writ of mandamus. It is very simple court case. What we are doing, or what any lawyer does, is we file a court case where we say that, look, the USCIS, when they published the 485 application, though, they said that they're going to adjudicate the application within 6 months. Now, my client's application has been pending for more than 1 year and the final action date is current. So please adjudicate this application. We're not telling them to approve it because we can't dictate them to approve it. Just decide on the case. Is it approval? Let's say, for example, this guy has some criminal history and he's not supposed to approve. Deny the application. Nothing wrong in denying the application if the guy is not eligible. But if the guy is eligible, please approve this application. That's all we're telling. Typically, we file a court case, and normally the government settles the matter because in general, they don't want to fight these kind of things, which were approvable in general, though. Means if there is no, everything is clear, they should have approving it. So we recommend contacting Stephen Brown, who is our other partner. Emily, our law office name is Reddy Newman Brown. That's Brown. You contact Stephen Brown. He should be able to take care of it. You can send an email to stephen@rnlawgroup.com, or you can send it info@rnlawgroup.com. And please include your 485 receipt notices, I-140 approval, and he will tell you normally how the things will work out in filing the writ of mandamus. Um, yes, you can contact the ombudsman. That doesn't work 99% of the time. You can contact the congressman. That doesn't work 99% of the time. You can contact the USCIS for expedited service. That doesn't work 99% of the time. So you can do all of those things, or you can do this other step, which probably is a better thing to utilize your time. Anything else, Emily, before we go to questions?
Yeah, I would also say if you need to file a supplement J and you were waiting for either an RFE or an interview and your date's current, you might want to consider just going ahead and filing it as a way to get someone's attention and get the case moving. You could also potentially interfile your medical exams if those have expired since you've been waiting. Those are some ways to just bring it to someone's attention. I'll usually, when I do that, include the visa bulletin with my packet and hand write on there priority date current. So it just catches someone's attention so that they will take action on it. Those have been some ways to kind of speed things up a little bit besides the writ of mandamus.
Emily, I just want to give a couple of updates to the people that we have not included. One is that if there is any 485J RFE, that is requesting the job duties are quite different than the labor certification than that of what you actually do. Definitely you want to take this very seriously. We have had a denial recently of an 485 application where they cited that the labor certification duties are quite different than the current duties. Also, when you go for the 485 interview, the way you should present what the job duties are and what the job duties you have, we strongly recommend you either you have a mock interview done by an immigration lawyer before you go to the interview, because we have seen one or two cases of 485 denial in the interview because the job duties are not matching. I mean, obviously, I mean, the labor certification of you was filed when? I mean, that was filed in 2012 or 2013, right now 2026. Now, the reality is that people will not be doing the same kind of things what they have done in 2012. I mean, things improve it. However, there is a difference. The USCIS sometimes may not understand that very clearly, though, because the way USCIS works is different than that of the industry, especially IT industry is changing very frequently. So that is one thing that we want to caution. Also, the other thing is that Emily and I have been recommending from the beginning that if you lose the job, you within the 60 days, we have recommended for a B2 application. However, right now we are having backlash. Emily has published an article on RN Law Group blog on the trap of the B2. Emily, can you explain why this B2 is not working and what are the steps for the people that they should do if they have already filed for the B2? And what are the steps if they lose the job? What are the other suggestions that you do right now?
Yeah, so going back to the Biden administration, they made an update on their website that made it very clear that filing a change of status after a job loss is an option. It is permissible while you are on that B2 to search for jobs. And if you do find that new job and file a change of status back to H-1B while your B2 is still pending, USCIS will prioritize the B2 and adjudicate both the H-1B and the B2. So you'll go seamlessly from H-1B to B2 back to H-1B. All of that was on their website. All of that was being followed by USCIS for years. I mean, we never even had RFEs on the B2 applications or on the change of status back to H-1B until late January. All of a sudden, we start getting all of these RFEs on the B2 saying that you said in your written statement that the purpose of your B2 stay is to search for jobs. That is not a permissible B2 activity. Well, that's funny because your website says the exact opposite. It very clearly says it's a permissible B2 activity. And there, it seems very clear that someone somewhere within USCIS decided that they're not going to follow their own guidance anymore, and they want officers to deny B2 applications for people who filed for the purpose of job search. They did not announce this policy change anywhere. They're applying it retroactively to people who already filed in reliance on that old policy. So if they want to change the policy, fine, go ahead and do it, but make it public. Give it a start date and do it going forward. You can't do it going backwards after people have already relied on it. And then that's where the trap is, that on one hand, they're saying, yes, you can do this, and they're inviting people to do it practically. And then after you've done it, they're turning around and saying, oh, no, you can't do that. And you're, saying they're even had the nerve to say that, oh, you pointed out various articles that suggest this can be done, but we say you can't do it. Well, the article is your own website. It's not an article, it's your guidance. And yes, it's archived, but if you want to archive something, explain what's part of it is being archived and why, what's out of date. There are plenty of things archived on the USCIS website that are still valid law and still valid policy that we follow all the time. So they're just going about this in a very backhanded way, a very unfair way. So if you are in that situation where you filed your B2 and you have an RFE, you need to make it very clear that you have the resident abroad. They're very much asking for those documents. You need a lease or a deed or something from the residence abroad. And if it's not your own residence with your name on it, you need to prove the relationship to the person that has the residence and get a statement from that person confirming that you're able to move there at the end of your stay in the US. They want to see financial records, not just a bank statement. They want to see 6 months worth of bank statements. And don't just submit your bank statements without looking at them to see if they're actually helping your case. I see a lot of people submit bank statements showing they have $100 in the bank. Well, that's not going to prove how you're going to support yourself for 6 months. You can't live on $100. So if you have lower balance in your bank, submit your investment accounts that show you have tens of thousands of dollars sitting over here that you can liquidate in order to support yourself. Or if you have someone else who's supporting you, provide that documentation and information. Just most importantly, take these seriously. I see a lot of responses that are just, you asked for this, here's this, you've asked for this document, here's this document, without any kind of additional explanation, nothing clarifying it, nothing explaining how it meets the requirements or qualifies. And so you're leaving USCIS to come to their own conclusions. You have to connect the dots for them of, I'm providing this document, this is what this document proves, therefore I qualify for whatever it is I'm filing for. You have to walk them through that analysis. Now, if I'm someone who has a job loss now and I'm trying to figure out what to do I choose the B2? Maybe not. I mean, we don't have any policy announcement. We don't even have results yet of the cases where we have responded to these types of RFEs. So I can't say, yes, we're responding and it's working, or we're responding and it's not working, so don't do it. We don't know yet. Everything's in flux right now because this is all so new. You may want to consider another visa category like F1. Certainly, if you have the H4 option, that's probably going to be your best option, but next option might be F1 because you have premium processing. That makes it much easier later to convert back to H1B because you can get your approval quickly. And also be aware with an F1 though, that you have to have your start date of your program within a certain number of days of when you lost your H1B status. And so if you're losing your H1B status tomorrow and you get an I-20 for the fall 2026, that's not going to work. So you have to be very careful on that. But F1 also requires the non-immigrant intent, the financial resources, the residence abroad. So they're very similar in that regard, but at least we have premium processing. I think the hardest thing is if you have to choose to leave the US, especially for H-1B holders, be aware how the $100,000 fee kicks in. It does apply. If you leave the US and your new company has to file consular processing, the $100,000 fee applies, which means there's likely not going to be a way for you to get back into the US while this $100,000 fee is in place. It currently is set to expire September 30th. I would expect it's going to be expanded or extended. I don't have any rumors of that, but that's my guess as to what happens just based on the Trump administration and what we're seeing.
There are a lot of questions with regards to the visa stamping, guys. We are unable to crack it, how to get the visa stamping. So if you would contact expecting that, okay, Reddy Newman Brown PC is going to get a visa appointment for you, we cannot. We don't have that ability at this point of time. So there are questions that are asked. 1-year-old kid, a US citizen, is stuck in India because his father cannot get the visa appointment. Can they contact the congressman? Would it be any help? People have tried those kind of things, that the kids are stuck there because of the school, because of the vaccinations and all those things. They have been not successful. There's a gentleman by Ram, he's saying that one of his friends' father passed away. And can this friend go to India to get expedited? Their argument will be one thing. I mean, nobody's telling that he cannot travel to his home country. The only question is that coming back. So unfortunately, the father passed away, but that doesn't in any way guide the consulate to give them the visa, because it's the father is actually in India, not here. So that doesn't do an expedited process for him to go to come back into United States. We have tried all different things at this point of time. Visa appointments are not working out. So we'll have to see as the things will progress. We will update you if there is any development that pops up. Anything else, Emily, on the visa appointments?
Nope. I can go to questions. I have one from Ravi Kumar. He says, my I-797 is valid until May 2027, but my visa stamp is until January 2027. So what is the timeline that I should take for submitting the visa extension? When you say visa extension, I'm assuming you mean your status extension. When you're in the US, when do you file your renewal of your status? Well, it's actually not based on either of those. It's based on your most recent I-94. That most recent I-94 could be the one that's on your I-797 approval that's valid till May 2027. But if you traveled after you got that approval, your most recent I-94 is going to be the one that's on the CBP website. And you need to log in and verify, does that one also say May 2027? If it does, it's supposed to, that's your expiration date. You need to file your renewal by then. There are many people that when they check their I-94 on the CBP website, instead of saying May 2027, it'll say May 2025 because that's when their passport happened to be expiring when they were traveling into the US last time. That's a big problem when we're in March 2026. That looks like an overstay. And if you file a nunc pro tunc extension with USCIS in that situation, thinking they're going to forgive you in their discretion because of it's an extraordinary circumstances, I'm sorry to say they are not approving those. I have seen so many people that the nunc pro tunc was denied because they say it's not an extraordinary circumstance. You should have known better. So be very careful of that. Always check your I-94 online. Now, of course, if you entered and then you file an extension, the online I-94 does not update. The new I-94 is the one that's on your approval notice. But if you got your approval notice and then you traveled, the one that counts is the one from when you entered. And if that's shorter than your I-797, you need to make sure to take action before that one expires.
A question coming from Gattleman. His place of birth is Naspur, but in the passport it's spelled as Naspoor. Will that be in the birth certificate? It's different. In the passport, it's different. Will that be any problem? I do not expect that any problem at all. Especially when you convert the languages, guys. There are hundreds and thousands of languages. When you convert one language to another language and you write it, you write it differently. Especially, I will tell you a simple one. Anita or Sunita or Savita. Now, when you spell it in North India, they spell it as differently. When you spell it as South India, they spell it differently. People write the spellings differently. That's perfectly all right. Does not cause any problem for you to get the adjustment of status. Abhishek has the same question on the adjustment of status birth certificate. Does it has to be registered within a certain time? It if it does register within like 2 3 years, that's perfectly good. If it registered late, for example, if it's registered at 24 20 years 25 years, they may issue an RFE to ask some other documentation like Aadhaar card, PAN card, ration card, election card, affidavits, and school certificate and hospital certificates. Those kind of things we may supplement it. We have had no problems when we supplemented it with those things. I do not like to supplement it initially when I file the adjustment of status, but if there is an RFE, I will supplement it afterwards.
Nature Hunt asks, what are the chances of getting the H-1B selected in the lottery with a level 1 prevailing wage? I wish I had a crystal ball to answer that question, but there is just no way of knowing because we don't know how many people are going to register. And of the registrations, we don't know how many are going to be level 1, 2, 3, or 4. USCIS expected that the number of people selected under level 1 is going to be fewer than it was last year. And the number of people selected in level 4 is going to be more than it was last year. But that's based on the H-1B application filings, not the registrations, because the registrations never gave a wage level before. So they're just assuming that based on the randomly selected petitions, let's look at what the wage levels were on those. It's also not taking into consideration the fact that some people are going to try to submit under a higher wage level if they can. So when last year you would have been submitted under level 1, maybe this year the company is making some changes to get it to level 2. So we truly have no idea. So anything that we would give you as chances of getting picked is going to be a complete guess. We can't even give an educated guess at this point.
Uh, Question with regard from Sitapa. My I-140 is approved. Can I later switch back to H-1B from H-4 EAD without the $100,000 fees? Since you are in United States, you are in H-4 in United States, you can switch back to H-1B without subject to the lottery. I'm sorry, without subject to $100,000 fees. Absolutely not a problem. The $100,000 fees is only applicable if you leave the country. If you are within United States, $100,000 is not applicable.
Um, Yogu says it's been 14 months. My spouse and son didn't get their H4 extension approved. What do I need to do as next steps? Well, I would look at doing a service request online. You can do an e-request for outside normal processing time, assuming that USCIS agrees it's outside normal processing time. You first have to enter your receipt date, and then it will tell you if it's time to do a service request or not. If that is not successful, I would say, is there a need to get it quickly? Because for an H4 that's pending, you are in a period of authorized stay. You can stay in the country and continue to be here the entire time it's pending. There's no deadline for you to get it, assuming that the H1B holders H1B has not expired and isn't expiring anytime soon. Now, you may be in a situation where your H4 is pending and because of it, you can't get your H4 EAD or you can't get your driver's license renewed or something like that. In that situation, litigation is probably going to be your best bet, and Stephen Brown in our office can help with that.
Um, Mufa Dazal from YouTube asked this question: have you got any exemptions for the $100,000 fees who are subject to the $100,000 fees? We know that some of the people did apply for it. We haven't got them. They are just not responding to it at this point of time. That is how the government policy is at this point of time. So we haven't received any exceptions.
Um, Tirupati says, I'm in the EB2 category. My priority date is current now, and I switched employers. I want to file the 485J. Can I also send the medical with it as well? You can send them at the same time. However, they technically go to different addresses. The 485J has a separate filing address that's not the filing address where your case is actually pending. And so you may want to send that in two separate packets, one to the 485J filing address and one to the address or service center or field office where your 485 is actually pending.
Some people are asking questions whether the US Indian consulates will be closed in India, very similar to the Middle East or Pakistan. Absolutely not. I'm not thinking that Modi government will allow any protesters coming any nearby to the US consulates. And I don't think so. He will do that. He will allow it. So I'm not expecting any disruptions for the consulate duties in India for the US consulate, as what we have seen in the Middle East and all the way to Pakistan. I'm not expecting that in India at all.
Deepak says I received annoyed for the H-1B extension for past law enforcement interaction that was back in 2012. How should my attorney handle this, and should I be worried? Well, it all depends on what the law enforcement interaction was and what the outcome was. I can say that for, our office, we have been able to get approvals of these types of H-1B extensions. Very commonly, I don't think we've seen a denial of cases that we have handled in this situation. Typically, we provide some of the documents relating to the court case or the arrest. Depending on what's in the document, we may choose to leave some out. We don't submit everything. USCIS gives you a laundry list of things that you can submit. Just because they say here's one thing you can submit doesn't mean you have to submit all of it. You need to prove by the documents that you're qualified for an extension, meaning you're not inadmissible and you're not removable. And then because of the way they're looking at this, they want to see that this one negative discretionary factor is outweighed by enough positive discretionary factors. So we provide a lot of evidence of the positive discretionary factors and explain why this person deserves to get the extension. We provide their education documents, proof that they went for their biometrics notice, proof that they've gotten all their visas before and have always maintained their status, proof that they have volunteered for organizations, they've done charitable donations, that they've had a strong working history, that they have paid all their taxes, that they have US citizen kids. You can make your own categories for what counts as positive discretionary factors. Of course, the evidence has to be valid and real and legitimate. I'm not saying make your own evidence. I'm saying that you get to decide what you think is a positive discretionary factor, and you get to submit those documents to prove it.
Haritha has this question. My natural parents have visiting visa, but I have a stepmother. How can I get her a visiting visa? Yeah, you can draft a letter saying that she is your stepmother, and then you can request them to issue a B1 B2. There's nothing wrong in it, especially the Western countries do understand what the relationship of stepmother is, and that's very common. So I don't see an issue as long as you explain it in the letter. It's not an issue at all. Uh, Question from Prasad. How do I update the H1, my new H1B approval for the existing H4 in the EAD application? There are a couple of steps that I would recommend you do. You can interfile. You can do it by creating a My USCIS account and request them to approve the H4 and EAD until your new H1B approval. And also, please, when you include the H1B approval, also include the pay stubs along with it. I also recommend that you refile the H4 plus EAD, even though you update it. They may not update it properly, though. So I want to take the corrective action. One, do the update for the interfiling and my USCIS account. At the same time, file one more H4 plus EAD while one is pending.
Gayatri says, in case of a job loss in H1, if we switch to H4 during the 60-day grace period, are there any risks of denial or a notice of intent to deny? Asking this because change of status to B2 are getting denied in recent times. I mean, you're never guaranteed an approval, but assuming that at the time of filing, you were maintaining your H-1B status or within the 60-day grace period, and at the time of filing, your spouse was maintaining their H-1B status, there's not a lot that can go wrong with a change of status to H4 if it's filed properly and timely. So no, we don't typically get RFEs on H4 applications or NOIDs on H4 applications because you don't have to prove the purpose of your stay. You don't have to prove your intent to depart. You don't have to prove your financial resources and all of those things that are in the B2 applications. All you have to prove is that your spouse is maintaining H-1B status and that you're married and that you lawfully entered and that you were maintaining your status.
Can you travel to Canada with a valid I-94 and a valid Canadian visa? Yes, you can. You don't need a visa to come back into United States only if you're traveling to Canada for less than 30 days and you have not made any visa appointment. Let's say you have a I-797A approval with company A and you're working with company A that has an I-94 at the bottom, and you have a Canadian visa, you travel to Canada and you are staying there for less than 30 days, you have not made any visa appointment, you can come back using the I-797A approval, which has a I-94 at the bottom.
Immigration Dream says, if my priority date becomes current, but I still don't have the perm and I-140 with the current company, can I still get my H-1B extended beyond 6 years? Or is it that the H-1B only gets extended if the priority date is not current? So I'm assuming you must have an I-140 from an old employer, but you're not able to file the 485 when your date becomes current because you don't have a perm or I-140 with the new company. So you can still use the old employer's I-140 to continue getting H-1B extensions. But if at the time of your H-1B extension, you're extending beyond the 6-year limit and the final action date is current on that I-140 that you're using, you're only going to get a 1-year H-1B extension. Now, if that final action date has been current for an entire year, and then you're filing the H-1B extension, that 1-year extension is actually discretionary. They could choose to deny it if you don't have the 485 pending. So you need to time your H-1B extension carefully. If your date is not quite current yet, maybe you think it might be next month, you could potentially file an H-1B extension early by filing it as an amendment plus extension and get a 3-year H-1B now, get it locked in to buy yourself some more time. So that would be one thing to consider in that situation.
Vaishal is asking question. I received the H4 EAD today. Any idea what it can be? Most probably it could be some technical issue. Maybe the pictures did not went through the I-140. They may not have it properly. They may ask you for the pay stubs of your husband. Those are mostly the H4 plus EAD should only be technical things. should not be of any other things that I can imagine. Um,
Dumont
Second.
says my PWD for perm was resubmitted in December 2025. Internal posting was done this month. My H-1B recapture is valid only till April 2027. What are my options? Um, well, you can travel outside the US so that you can recapture more time. Of course, travel is a risk right now, so that may not be a great option. You can file a change of status to another type of visa. Maybe you're married and your spouse has an H-1B as well. You could change status to H-4. If that's not an option, you could potentially change status to F1 and then convert back once your labor certification and I-140 are approved. Not a lot of great options, but at least you're asking about it a year in advance, which gives you more opportunities and options than waiting until right before it expires to try to do something.
AN India for you asked this question. I think so. He has the 485 pending in EB5. And can I switch to EB2? There are ways to do it. If you have a non-immigrant visa, then definitely you can. If you already filed the adjustment of status and you are already lost your non-immigrant visa status, though, you can try to switch to EB2, but sometimes it may not be successful. So definitely, I would recommend that you contact an immigration lawyer. I would prefer that you get a green card in EB2 over the EB5. The reason is that EB5 green card is only conditional green card. It's only valid for 2 years. After that, the validity is over, and then you have to apply for the conditional removal. There are some risks. There are major risks involved in EB5 as compared to the EB2. So definitely evaluate it. And there are also other options. If you cannot file the adjustment of status, you can even request the EB2 I-140 to be sent to the consulate, where you will go to India to get the stamping there in India, so that if your non-immigrant status is not there, you may probably choose that consular processing.
Leonardo says, does premium processing override or bypass the policy memo 6020192 hold procedures or from presidential proclamation 10949 countries? So if you're talking about the immigrant benefit pause that is due to certain countries, premium processing does not override that. So you can file your I-765 in premium, they'll take your fee, and then they will sit on the application and do nothing with it because it's subject to the benefits pause. And they will not refund your premium processing fee until they eventually process the 765. So it might be some time before you get that money back.
Swapnika has a very interesting question. She believes that she is not qualified for EB1A. She believes that she is qualified for EB2 National Interest Waiver. Do you recommend filing the National Interest Waiver? Absolutely, yes. The reason is that you may not be qualified for EB1 right now, but you may should to get qualified later on. What is it? Why is it an advantage to file a NIW right now? Is that you will establish a priority date. So when you move to EB1, you can move the priority date of national interest waiver, which is under EB2 to EB1. So definitely it is very, very advisable, strongly recommended to file a national interest waiver right now.
Naren says I-140 is approved. H-1B expires March 5th, 2026. There's an amendment plus extension that's pending since October, but the employer is not willing to upgrade it to premium, and a job loss is expected April 30th, 2026. What are the options after April? Your options need to be March 5th. Don't wait till April to do something, because it's very likely that if you wait until April to file something, that filing is going to be dependent on getting the amendment plus extension approved. If that job is gone and an RFE comes, they're probably going to either withdraw or you're going to get a denial. That creates a gap from March 5th till the date you filed whatever it is you filed. So you need to file something before March 5th, 2 days from now, because that's only 2 days from now, I'm expecting that a transfer is not an option because there's no time to get an LCA. So you're probably looking at filing a B2. Of course, we've stated all the problems that are happening with B2, but you don't have much other choice. But please don't wait until April to do something. Don't wait until you get the amendment to denied to do something and try to do a nunc-pro-tunc. Those are not successful, and they're also resulting in NTAs because your I-94 is expiring. So if you get a denial of a nunc-pro-tunc and your I-94 is expired, you might end up with an NTA. So you need to treat this very seriously.
Manoj has this question from YouTube. What is the easiest way to move from H1B to already approved H4 and H4 EAD? So let's assume that you have an H4 EAD, H4 plus EAD approval until 2028. And now you have recently got this H1B approval. Now you want to move back to the H4. The easiest way is called Margarita switch. What is Margarita switch? You go to Mexico, and of course, if you don't have a visa stamping your passport, you may have to get the Mexican visa, which is very easy. It takes about a week's time. Everybody said it's so easy to get a Mexican visa. You fly to Cancun, you spend about 1 day or 2 days there, and then you fly back. When you fly back, you show your H4 approval. And the people ask the question, I don't have my H4 stamping in my passport. How can I come back on H4? It's called automatic revalidation. You can Google it out. It's there on the CBP website. If you have a valid I-797 and you I-94 is attached at the bottom of it, which you said you have H4, you can come back into United States on H4, and voila, your EAD becomes active. So that's so easy. You can file a H4 plus EAD, which may take approximately 6 months to 1 year, or you just go to Mexico and you come back. We call it as Margarita switch because Margarita is very famous in Mexico.
PVM says, I'm hearing people are having issues with getting their driver's license extended after H-1B extension approvals. Are you seeing similar issues and how to handle? I've not come across that. Usually the problem with getting the driver's license extended is when you're trying to use a receipt notice, because some of the states don't accept that, even though you are lawfully in the US and allowed to work for 240 days. You just apparently can't drive to work. So yeah, I'm not seeing that, but typically you can, there's like a save self check that you can do to see what that says. There's a way to see what the status is if they've done a save request at the driver's license office. You can check online to see what the status of that is. You might have to talk to a supervisor at the driver's license office. It's possible that just the approval information didn't get sent over to the save system for some reason. I don't have a lot of answers there, but it's going to be just a lot of following up with people.
Common Man 1708 has this question. If I lose the job, should I look for the jobs on the H1B, or can I continue my job search on the EAD 485 EAD? He filed a 485 application. I definitely recommend that you contact an immigration lawyer immediately. The reason is that there is a 60-day gap period that's allowed in the H1B, but that 60-day gap period is not there in the 485 application. What does that mean? Is that if you lose the job and if you have a gap period of 60 days, the 485 can be denied. Now, self-employment is allowed if you don't get any job in the 485 application. The USCIS regulations are very clear. The memorandum from USCIS is very clear. Self-employment is allowed. If you don't find a job, self-employment is a better deal. Definitely, that means moving on to EAD. There are under certain circumstances you can even file H1B. But yeah, EAD probably is better, but having no gap employment, as least as possible employment gap, would be in your best interest. You should contact an immigration lawyer immediately.
Nomad 10 says, why is the perm approval taking 17 months now? There is no good answer to that. There's no excuse for it. They just don't want to help immigrants. This is a very anti-immigrant administration. not just at USCIS, not just at Department of State, but Department of Labor as well. They have no motivation to try to make processing times faster. I gave them the benefit of the doubt when I started seeing longer processing times because it was based on when all the prevailing wages got messed up. When they tried to change prevailing wages, there was a big rush of applications, and then they had to go back and reissue a bunch of them after they got shot down in court, and that kind of put things behind. But they've never even attempted to try to improve processing times, and they don't think 17 months is unreasonable.
People are asking question, is the H4 visa appointments backlogged everywhere else, or is it just India? Definitely India only. They are a little bit backlog in other countries, but the amount of backlogs that are there in India are not there anywhere else. So one of the questions, Srinivas has this question. My wife has an H-1B visa valid, and she recently changed to H-4 last month. Can she travel from India to USA without H-4 stamping with valid H-1B stamping? Absolutely not. If you don't have a job and your H-1B is not active, you're not going to work for the company. If you travel into the country, since the H-1B will be withdrawn, or even if it's not withdrawn, they may ask question, do you have a job? If you don't have a job, because the whole purpose why you're coming is for the job, and that is not, they may detain her and put in detention for a couple of days before they send her back outside the country. So the answer is clearly no. She should not come back on H1B. She should wait for the H4 appointment, then only she can come into United States.
Special K from X says H-1B renewal is due in October 2026, but passport is expiring in January 2028. Will the new I-94 be valid till January 2028 only? No, when you're filing a renewal, USCIS does not look at your passport expiration to determine your I-94 validity. They'll give you the 3 years that the company requested, even if your passport's expiring before then. When people get cut short on the I-94 due to the passport, it's when after they get that approval, they travel on the passport that's expiring in January 2028. Then at the port of entry, they give them a new I-94 that's only good till 2028. You need to take action before January 2028 because that becomes your new end date, not the end date that USCIS gave you.
AR Kids 2018 has a very interesting question. If the dates become current, he has an issue right now that his current company is being purchased by another company. What are the options? If the purchased company, the new company that you will be working for, meets the requirement of what we call as successor interest, the new company can file an I-140 without filing a POM application and file the adjustment of status. Now, people will ask the question, now, how is this successor of interest determined? If the new company is going to take the responsibility of the labor certification, though, I would say that 95% of the purchases of the company, when the company A has been purchased by company B, 95% of the companies meet the requirement of the success of interest. Now, how do we determine whether your company is going to meet the requirement? Definitely, you have to speak with your HR. Or if you allow us to speak with HR, we can determine whether the new company is going to meet the requirement. As I said, 95% of the companies will meet the requirement. So you can check with your HR on that, whether the new company meets the requirement. If it meets the requirement, you don't have to file a labor certification again. You just have to file an I-140. That means if the date becomes current, all you do is that file an I-140 and file the adjustment of status. Because labor certification takes, more than 2.5 years nowadays, even 3 years. So definitely, if it meets the success of interest, you are in good shape.
Srinivas from Facebook says, is the H-1B lottery based on salary or experience? The company is not ready to file in the level 2 prevailing wage because of fresh undergrad. What are your thoughts on this? It's based on salary. So they just look at what is your salary offer And for the SOC code that you're going to be working in, what is the prevailing wage level that meets? So if your salary offer is $100,000 and level 1 is 90,000 and level 2 is 110,000, you are going to be level 1. You're only going to get one slot in the lottery. If the company wants to get you more slots in the lottery, they have to agree to pay you 110, even if you don't have the experience that would normally go for someone to be paid 110. I don't think there's a ton of companies that are willing to overpay for people based on their experience. So they're probably going to stick with whatever the salary equates to.
Here's a question Srini has. I had a DUI. I'm an H1B in 2023. And after that, extension has happened. The DUI case later one was dismissed. Dismissed. There is no conviction on it. When I file the H1B extension next year, will that be any problem? Yes, they will ask you to come for the biometrics. However, they are going to approve the H1B. We have not seen the H1B getting denied. They will ask you to come for biometrics. Sometimes they may ask you to provide the documentation of your arrest and the case dismissal documents. And after that, they are approving it. Now, going to the consulate definitely is not a good idea right now. They are not giving the stampings for anybody who has a DUI right now. Definitely, we are telling everybody not to travel. Now, Stephen was recently was discussing, and Emily, and we were all discussing this, guys. We get every single day a DUI consultation. And believe me, it costs a lot of money for an individual, immigration wise, criminal case wise. The strain that they took, guys. Please, if you drink, do not drive. Take the Uber, and then go. It's not worth discussing with us. It's not discussing with a criminal lawyer. It's not discussing with anything. It's Uber is worth. That $50 that you pay is definitely worth dealing with Emily, dealing with Rahul, dealing with Shivan, or anybody in our office, or dealing with the criminal lawyer is not worth. It's really painful. It's very costly. Trust me on this one. Take the Uber. It is very good. And the Uber guys, you sit in the Uber, you do not get the DUI if you are not in the driver's seat, of course. If you're a passenger, if you have taken alcohol, I guarantee that nobody will give you the DUI. Anything else, Emily?
I think we're out of time. Thanks everyone for joining us. Again, we'll be back next week on Tuesday at 5 o'clock Central Time. In the meantime, if you'd like to consult with us or any of our attorneys, you can go to rnlawgroup.com and click on the button for consultation. It'll take you to our calendars. You can book it online.
Thank you very much for tuning.